What school administrators ought to know about student privacy in the era of the app. When it comes to managing student privacy and educational technology, there are three major federal laws we ought to consider. The first is the Family Educational Rights and Privacy Act, which manages educational records and student directory information. It's enforced by the Federal Department of Education. Then there's the Children's Online Privacy Protection Act, which says that children under the age of 13 may not register for online services. It's important to note that it is not about students, but rather children. So that means that students over the age of 13 may in fact register for online services, to use online services and tools. This is managed by the Federal Trade Commission rather than the DOE. The Children's Internet Protection Act is a policy that states that schools that want to receive a discounted E-rate for their online services, schools and libraries that want to receive that discounted E-rate, must in fact have a content filter put on their systems that prevent students from accessing pornographic, obscene, or potentially dangerous materials. It also states that schools must monitor student online activity and that they must provide digital citizenship instruction. A lesser-known law is the Protection of Pupils' Rights Amendment that entitle parents to opt their students out of surveys regarding their students' personal histories, or also to review those surveys before the students take them. It also allows parents to review educational materials. This act is managed by the Federal Department of Education. Students' rights of privacy and educational technology also raise a number of constitutional issues. The First Amendment comes into play when it comes to freedom of speech and expression. What happens when a student is using an app to express themselves, and that app is being used on a school device, but it is not an app that has been deemed okayed by the school? What happens if a student is expressing themselves in an online environment in the service of a school assignment, but again isn't using a school-sanctioned tool to do so? Where does the school's liability fall into place there? And what can they do to limit or not to limit students' freedom of speech? Issues of the Fourth Amendment come up in investigations of such behaviors because we have to wonder about what does it mean for an unreasonable search and seizure when it comes to looking at student information done in app-based technologies. What happens if you need to use student passwords to access information or access their records? Where does the law fall with regards to those? And that ties into the 14th Amendment and due process and making sure that that is not violated simply because we're working in digital environments. All of this comes around to understanding that we are in a brave new world of learning, a new world of technology, a new world of laws. There are going to be many undefined situations in the coming years, things that we just haven't thought about because they didn't exist as issues until now. In order to better keep pace with the rapidly evolving technology, many states have started to pass their own student privacy protection legislation. One such is the Student Online Personal Information Privacy Act passed in California. It's important because it shifts the burden of student privacy from the schools onto the EdTech developers and services themselves. In Maine, a Student Privacy Act was passed that reinforced the rules set forward in FERPA, but also the Social Media Privacy Act, which is an interesting policy that states that schools may not ask students for their passwords to their private social media accounts. However, schools may still monitor activity on those accounts if conducted on school devices. They simply may not ask for the passwords. Well, I guess they may ask for them, but the students are not required to give them. we have to be very, very careful with terms of service agreements. It's very easy to click the little box and jump through all of those pop-ups that show up when we register for a new service, but often those can create security exploits and privacy exploits that we weren't even aware of. So it becomes so important to have a proper whitelist of approved technologies for your district and for your school, and to keep those lists accurate, up to date, and robust, so that teachers can easily find the tools that they need to use to help students with their learning. Google Apps for Education recently was a subject of a lawsuit where students accused them of data mining their information for targeted advertising. Turns out they were not actually using it for advertising at all, but they were using non-personally identifiable information to improve their services. Since then, Google has updated their terms of service, has become much more transparent about how they are using student data, and the lawsuit was dismissed. Edmodo is a blogging platform that many teachers use because it creates a private space for students to practice the act of blogging, but to do so in a way that not everyone can see. However, it turns out it was not as secure as they thought. A parent with a background in security management, online security management, was able to exploit the weaknesses in Edmodo's system and show them just how easy it was to find student information on there. So Edmodo updated their security protocols, they changed their terms of service, and now they actually offer toolkits that administrators and educators can download to help them navigate these waters and to help them better vet other educational technologies. Yelp got themselves into trouble for violating CEPA by continuing to allow students under the age of 13 to access its review online service, and was fined $500,000 for doing so. They were not the only ones. Several game developers, very popular with students, were also found guilty of doing so. We have to be very careful with iPads because a lot of educational technology likes to use Flash. The trouble there is that Flash does not run on an iPad. So in order to make it work, many students and teachers will download other technologies that enable Flash to operate. Often those technologies bypass content filters that maintain CEPA compliance. That's a problem. So it becomes that much more important that we help those teachers to find workarounds that don't violate CEPA while still maintaining meaningful, robust educational technology experiences. With the proliferation of learning management systems, content management systems, and student information systems, we have a lot of questions raised about what happens to all that data being stored in the cloud. And what happens if ownership of those systems changes hands? For example, PowerSchool was just sold to a private equity firm, and many folks are concerned that now there will be a change in the terms of service, and that private equity firm will find a way to create opportunities to use student data to create revenue. So how might we manage this all? How might we manage the apps? It's not that scary if you follow some basic protocols and basic mindsets around educational technology. One, administrators need to have a more informed understanding of EdTech. 95% of all security exploits are the result of human error. That's a result of a recent IBM study. So get out there and get informed. Engage in social media, go to professional development, read, find out what it is that's going on in educational technology right now, and have a knowledgeable point of view going into making policies. And when you make those policies, make sure they're in plain language. It's easily understood by all of your stakeholders. And at the same time, make sure you vet those policies with other administrative peers and with your legal counsel, because oversimplification can create even more problems than it solves. Ultimately, you want to have an efficient educational technology adoption process. You want to avoid the paradigm of it being easier to ask for forgiveness than permission. You want to flip that. You want it to become easier to ask for permission than it is to ask for forgiveness. We can do that through transparency and trust and getting all stakeholders involved in the process using common sense approaches. Because really what we want to do is grow comfort so that we can create better learning opportunity.